Welcome, everyone. We're so glad you could join us today for our webinar, Cottage Succession Planning, a strategic approach to intergenerational wealth transfer. We appreciate you taking the time to be here. Before we dive in, just a few housekeeping notes. If you have any questions during the presentation, feel free to drop them in the chat box on the right-hand side. You can direct your question to our host or any of our panelists. We will save time at the end to answer as many as we can. If your question is more specific to HomeEquity Bank's reverse mortgage solutions, your HomeEquity Bank BDM or BDA will follow up with you directly after the webinar. Finally, this webinar is being recorded. If you would like a copy of the recording, please contact your HomeEquity Bank BDM or BDA. I'll now hand it over to HomeEquity Bank's very own Andrew Cairns.
Lauren, thank you. Joining everybody. This attendance at this webinar has set a record, in fact, which we're very excited about. We're being joined online here by financial professionals, financial advisors, mortgage brokers. We have bankers as well. Very, very exciting. I think we hit the nail on the head in terms of a topic. They told me that we couldn't talk about old age security clawbacks. It'd be better to talk about cottage succession or, for my friends out west, cabin succession planning. It is such a timely topic, and my marvelous guests that are with us today are going to really bring this to life in terms of what a more affluent marketplace is looking for. You may be surprised to know that HomeEquity Bank's CHIP reverse mortgage offering is increasingly being offered by financial advisors to integrate it into tax-smart planning strategies. And not only do we have the resources in terms of a solution, a custom solution, if you may, we also have the staffing nationally to be able to support it with the expertise, regardless of the channel that you would like to chat with us about, in order to serve you. And we'll be offering some instructions a little bit later. I should mention, in addition to this being recorded, this is also eligible for 1 CE credit. This may be your first of 2026, which is great, and we'll be able to get that to you. HomeEquity Bank, of course, is the original provider of reverse mortgages in Canada, the largest provider under the stewardship and ownership of the Ontario Teachers Pension Plan. With that, we made significant investments in order to serve all markets, and quite by surprise to many, the CHIP reverse mortgage, as I mentioned, is being integrated into financial planning solutions. So we'd be delighted to talk to you about that in a greater amount of detail. But helping me today, my marvelous guest here leading the conversation is going to be Pattie Lovett-Reid, who is our chief financial commentator for HomeEquity Bank. A long tradition as a financial commentator, known to our audience here in the same role in the national capacity on CTV and its affiliates, and a long history there, as well as being a senior vice president formerly at TD Waterhouse. Pattie's going to be able to do a great job to bring this conversation to light. Peter Lillico is got to be one amongst the most knowledgeable professionals that I've met, specifically an estate lawyer, but with a specialization on cottage succession. And both Pattie and Peter, I saw them recently at the Cottage Life Show that was offered here in Mississauga, Ontario. And it was just a tremendous presentation, standing room only. And it was hard to essentially let them get off the stage on time because there's so many questions were being asked about this important topic. And Peter comes with over 4 decades of experience in the specific expertise of cottage succession. So we're awfully glad to have you. And I know, Peter, also that you have a long experience with the Ontario Federation of Cottagers as well. So maybe I'll start it off here, Pattie, and you can lead us through this conversation, because we had an interesting conversation in the aisleway at the Cottage Life Show, and we were talking about your family's connection to your cottage in Haliburton, and some of the you noticed also a lot of for sale signs. What are you thinking there?
Yeah, there are a lot of for sale signs. And I got to tell you, Andrew, this gets really personal for me because I look at a cottage as a line on a balance sheet until it didn't. Until I started to experience the first swims, catching fish off the dock, not that I'm doing it, but the grandchildren were. Sometimes conflicts. I can tell you that for many families, what I've come to realize is that the cottage is, yes, a very valuable asset for some, maybe their most. For others, it definitely is their most emotional asset. I am absolutely thrilled that I get to ask Peter questions. And so what I decided to do, and Andrew, I'm going to ask you to chime in as well. I'm going to break this down into 3 components. We recognize who's on the line here. You are experienced, you're knowledgeable, and hopefully you're looking for a few nuggets that you go, that's an aha. That means I can do things differently. So we're going to talk about family readiness. That's the human side of things. I have here tax efficiency, and don't worry, we're not going to do capital gains 101. It's going to be about the financial reality and protection. How, if you want to keep the cottage in the family sustainably, how do you go about doing it? So that's sort of where we're going to kick things off. And so, Peter, I'm going to come and get right into it. When you decide to meet with a family for the first time, is this a conversation they feel they have to have? Or is it a conversation, or they're ready to have, or is it just one of these things that, I got to check the box?
Well, that's a good question, Pattie. In most cases, these are the cottage succession topic is something that's been on their minds for years before they actually come in to see me. They see how much the grandchildren are enjoying the cottage. They realize their kids couldn't afford cottages on their own. They realize that, in fact, the cottage is in some way what glues the kids together. The various cousins don't live in the same town. The only time they get to meet each other is at the cottage. And so it grows on them that this is a treasured asset, not just a financial asset, although there's certainly a financial number attached to it, but a real family asset. And so by the time they come to me, it's usually because They have felt that it should be easy. The kids like the cottage. We like the kids. Problem solved. And then it's far more complex than that, as we will discover.
Okay, so can you talk about that? It is far more complex. Are there signs that you would see as a red flag that this family's not really ready to have this conversation?
Well, the best sign, I guess, would be for somebody. I have to say 2/3 of the time it's the parents that initiate the conversation with me, and 1/3 of the time it's the kids. The kids may think, gee, you know what, the parents are getting on, and the effort of running the cottage is a lot, and what if they decide they're going to up and sell it? What are we going to do? And so they'll initiate the conversation. Other times it's the parents that realize that there will be a transition, and managing that transition is crucially important because they do see how neighbors that have been in the cottage for decades or generations, those for sale signs go up, and they want to avoid that.
And I think when you look at our demographics alone, the fact is we are an aging population. There is a transition going on. There's a transition of wealth. I guess what I sort of, when I think about the cottage, why would it not be a good idea to just say, okay, you know what, the last surviving spouse then deals with it? It's sort of one of these things I've heard you say, you got to deal with it long before that.
Well, of course, it definitely benefits from a planning process.
You break that down. What does that mean? What does it look like?
Well, the first part, as you alluded to, is family readiness. The typical way in which cottages get passed down is it goes from the parents as joint ownership. One parent will pass, it'll go to the surviving spouse. The surviving spouse then will keep the keys to the cottage in their own hand, and then when they pass, it goes on to the kids, and they've got a will that says everything goes to the kids. And that's one of the big reasons why the family is really not ready for it. It maybe wasn't careful thinking by the parents to say, we love the kids equally, so of course we're going to give them an equal interest in the cottage. And then some kid says, gee, I live so far away, I'll never be able to use the cottage. What was mom and dad thinking? I'd like just to cash out of the cottage, please. And so they ask to be bought out, and the other siblings say, hey, mom and dad are going to spin in their grave, and why are you asking for money? You didn't pay for it. And what could be a beautiful family legacy instead becomes a bone of contention. So that's one of the reasons. Another reason is just poor information about the tax consequences, poor planning on it, going the most inefficient way, misunderstandings about things like principal residence exemptions. But I would say in the last 5 or 8 years, the most common reason why the for sale signs sprout is maybe there's a transition, a succession in the sense that new names are on the deed after the passing of the parents. But then something happens with the children. Either the family dynamics don't go right, or there's a separation or divorce, or somebody runs into financial problems, which immediately impacts upon the cottage. And eventually there's a for sale sign. That's what we'd like to avoid with our planning.
Well, sure. And, you know, when you have more than one beneficiary of the cottage, there you do run into issues if it's not been addressed ahead of time. Who gets what prime weeks? Who's going to pay for the repairs? These are all part of the conversations, because these are tough conversations, but they're also in families, assumptions get formed.
Mm-hmm.
So what do you do there?
Well, one of the assumptions often is the parents who simply say, oh, our kids are nice and they'll sort it out. And, 90% of the time they're correct. They do have nice kids, and 90% of the problems will be sorted out. It's the 10%, though, that sink the cottage. When an issue arises that hasn't been anticipated in the future, and now it becomes the bone of contention. So what I say to my clients as their first step, long before they're ready to pass over the keys to the cottage, is you need to drill down with the children and have a conversation. We know you like the cottage. That's not the question. The question is, are you prepared to be a cottage owner? And even more significantly, are you prepared to be a shared cottage owner? If you've got 3 kids, unless you've got 3 cottages, it's going to be a shared cottage. And that leads to one of the planning solutions, which is I call a cottage sharing agreement, which has a discussion among the family members, makes the kids start thinking like owners. Once we are owners, should there be restrictions on the transfer? Can any of us sell to anybody at any time? Or is it to be within the family? What if somebody has to move to a different province? Should there be an exit strategy? Should it be a fair market value, a discount from it? How are we going to allocate expenses? All of these important things, which our professionals know, because somebody's inheriting a business, they're going to want these types of things. And then the litmus test is, okay, kids, you say you want the cottage. We're prepared to do our part. You now have to step up to the plate and do your part, which is to participate in getting an actual legal cottage sharing agreement in place. And if you are able to do so, and probably get back to us, with our assistance and guidance to say we've accomplished this, mom and dad, we've shown that it's important to us and that we can compromise and cooperate, then the parents can shift into higher gear to say, okay, now we can turn our attention to how will we transition? Will we do it now? Will we do it later? Or how do we deal with the taxes? Those types of things. That's
the next point. But before we get to that, I've often heard parents struggle, and they've often asked me, what's the difference in how do you address fair versus equal? Mm-hmm. How do you do that with the cottage?
Well, absolutely, that's what parents want. And that's why many of them make actually a fundamental error, which is to say, well, I've got to leave the cottage to all 3 kids equally, even though I know darn well one won't be able to, or will struggle to afford his or her share of the costs. Another one may be geographically distant and be able to seldom visit the cottage, but is still going to be expected to do the work that the other ones are doing. So it starts with the parents to have that conversation with the kids to say who's realistically going to be. Now, it can be, the fairness aspect can be initially, do you want to be a shared cottage owner? And if one says, please leave me out of that ownership, I love the cottage, but I'm not going to be able to visit enough, or I can't afford it. Some parents will say, okay, well, there's the fairness level. They've all had an equal shot at it. And so these 2 will get the cottage, and the other will inherit, a third of the sale proceeds of the house. Most parents, though, if there is one of the children that says, I'm not interested, or I can't be involved, they'll find a way to compensate them for the fact that they don't have a cottage ownership. Doesn't mean they don't get cottage usage.
Oh, how contentious is that?
Usually it's a great relief for somebody that lives in British Columbia, loves the cottage, bleeds cottage blood, knows that they really can't realistically be involved in owning the cottage, but then to find that into the cottage sharing agreement, they and their family are written in for a mandatory or 2 weeks of exclusive usage of the cottage every summer if they're able to use it. They're part of the cottage, they're part of the families, and they're relieved. Otherwise, they say, well, we've cut the tie with the cottage and our heart's broken.
I see. Okay, so how soon, how early? You know, when I often talk to people about putting powers of attorney, for example, in place, I like the idea of having them in place 5 to 10 years before you're ever going to need it. So the question is, when would you do these conversations? How early on? And is it ever too late?
It's far too often too late. There's sort of a sweet spot for the transition. So if parents get too elderly, if one of them has a stroke, if they have to sell the cottage because they have to go into a senior's residence, things like that, then there's the gnashing of teeth and, gee, if only we put our minds to this earlier. It's never too soon to start the planning. Don't confuse the succession planning with the actual implementation of the plan and the signing of a deed to transition to somebody else. There are these various obstacles to be addressed and to be overcome. And so to do the winnowing of the candidates early, and then to make sure that those candidates that are going to be suitable for shared cottage ownership get a cottage sharing agreement, and then how do we do the tax part, and then how do we protect them once it's there? It all flows. But the sooner you start, the more likely it is that it's going to be ready, because as we as professionals know, not everybody's going to have 84.6 years to get ready on these things. Things don't always work out in a timely chronological fashion.
Gosh, 84.6. Thanks for that reminder, Mister. Peter, before I move on into the tax side of it, because I consider that to be sort of the meat of it, have I missed something on the human side?
No, the most difficult part is to start that conversation within the family and to do it properly. And that may mean with the guidance of advisors that say, look, don't just ask a question, do you like the cottage kids? Because they're going to say yes. They may say yes because they mean it. They may say yes because they don't want to disappoint the parents. They may say yes because they like it because mom and dad have always got the beds made and the fridge is filled. And so it's like an Airbnb that they don't have to pay any money for. And then the real question is, are you prepared to be an owner? Are you prepared to do the work? Are you prepared to pay the bills? Are you prepared to, in due course, have a plan that passes it on to to your own children? And so you can't start that process too early. And the cottage sharing agreement is the sort of the goal for that family readiness part. That's the proof that they really are ready for cottage succession.
So, great. Okay. So if I'm just going to summarize here, if it's like me and my cottage is a line on our balance sheet, my advisor, they could at least approach the conversation. What are you doing with this asset? What are your thoughts on it? How do you plan on transitioning it? And they don't necessarily have to come up with the share agreement,
right,
but they can start the conversation. So this is a really key leverage point for advisors.
And another key point for the advisors is I can't tell you how many times I have my dedicated cottagers. Patty, you alluded to the fact of how special cottages can become. Mm-hmm. And even though the cottage may represent, on a balance sheet 25% of their net equity, it can be 75% of what they care about. And so many times advisors, because it is complicated, will in well-intentioned say, oh, sell the cottage before you're dead because it can be a difficulty. And right there, the client is thinking, this person doesn't really understand, and I'm going to get different advice in a different area. If instead they say, we do understand how emotionally important this is out of proportion to the value itself, and we're here to help you achieve your goal of having those grandkids playing on the dock, then you'll bond them to you.
Excellent. Okay.
Patty,
all right.
Patty, do you mind if I just, because Peter's brought up an interesting point that reflects on some of the practical experience that we've had here at the bank. And it fits right into the sequencing of this initial conversation. And the example he brought up is the child is outside of the province, let's say, and they're at the other end of the country or in the United States or something of that matter. And one of the trends that we're seeing in terms of the type of banking that we do is pre-inheritance in order to equalize children. In other words, the child that has moved to the United States, let's say, will likely not participate in the cottage, which involves the other two children. Is there a means to provide some degree of living equalization of the child that will never occupy that cottage? And the unique fit about what we do with the chip reverse mortgage program is we prevent the typical conversation of the advisor taking a redemption order, cashing out investments, giving rise to taxable gains, and actually using part of the real estate portfolio to facilitate the tax-free cash transfer to perhaps the child that is not going to occupy that cottage. Mm-hmm.
Peter, did you want to add to that?
No, that's exactly right. Of the three kids, there will probably be good and valid reasons why one of them may not want to be involved. And often there's a case to transfer the cottage during the lifetime of the parents, but there may not be enough liquidity just to hand over a similar amount of money. And the advisors are certainly going to say, don't dip into your registered retirement income fund and pay the tax penalties on that to do an equalization. And so Andrew's idea of a reverse mortgage, which doesn't have the tax consequences to free up some money to help them at the same time, is good. It can also be done upon death. So the children inherit the cottage, and then there's what I call a compensating bequest for the one that doesn't get the cottage. It may not be dollar for dollar. This is your equality versus fairness type of thing, Patty, that comes when the parents die, when there is life insurance or the house is sold and there is liquidity with which to pay the other people.
Okay. Thank you, Andrew. All right, I'm going to move in now to the tax efficiency, because the theme here are hidden costs, planning opportunities, and surprises. Given that we all understand what a capital gains is, I still think it's important to talk about. You tell me, Peter, should we throw it out there and say declaring a principal residence and then talk about the capital gains, or do you want to start with capital gains?
Well, one of the things that's not well understood is the principal residence exemption.
Okay,
and everybody's heard what it is. And if there's a particular deadhead that it's going to sink that cottage boat, it's misunderstandings of principal residence exemption. And one of the misunderstanding is people hear, the consumers, cottagers, hear the word principal residence and they think, okay, well, that has to mean my house, because, I'm 9 months at the house and I'm 3 months at the cottage. And therefore, even though I have a $488,000 condominium and I've got a $1.4 million cottage, I guess all I can do for principal residence is my house. And that is just not true. And I know the tax sophisticated advisors here know it's not true, but many people don't know that. And so they'll squander their principal residence exemption when they eventually sell their condo. Maybe even their advisor will just assume that they're going to use their principal residence exemption. And then they later find out I could have reserved that for my $1.4 million cottage. So understanding that the cottage or the house can be principal residence, and then opportunities for advisors to do an analysis, a very helpful analysis. They'll be tripping all over you when you say, listen, there's an alternative here that could save you $48,000, and here it is. So that's one of the misunderstandings, that the principal residence exemption definition is wider than people think. Then the other one thinks is, well, I own a house and a cottage. I will eventually sell my house and I'll downsize. I'll go to an apartment. I'll move to a senior's residence or something. And then I'm savvy enough to know that then my cottage will become my principal residence. So I'll use my principal residence when I sell my house and I don't pay tax. And then my cottage will be my principal residence. And because it's principal residence, when I die, there won't be tax to be paid. And so I can lavishly spend all my money, and the only legacy I'm leaving to the kids is the lovely cottage. And then it turns out, guess what? Although it was principal residence for a period of time, it is absolutely partly taxable and partly exempt. And therefore, all of a sudden, there's a tax to be paid by the kids, and the cottage gets sold because that's the only asset to pay the tax.
And so explain then how that happens, because you've declared your place in the city as your principal residence, you sell it, and then you move, and it is your principal residence for a period of time, not for all the time.
That's right. So the principal residence exemption was used, let's say the cottage and the house, just for simplicity or illustration purposes, were bought in the year 2000. And in the year 2025, they sold their house and lived another 10 years or whatever, 15 years, and the cottage was their principal residence. I won't say if or. I'll use the 25 years of owning both properties and then another 15 years for the cottage. So the total ownership period for the cottage is 40 years. Of that, they can't duplicate the principal residence exemption, that when they sold their house, their accountant will say, well, it's a disposition. You have to report the disposition, but then we'll claim the principal residence exemption so you don't pay tax. So that's where you actually come forward and make your decision as to what's the principal residence for the last 25 years. It's not something you do in advance by saying, well, I'll have my mail go to the cottage, or I've got to pretend that I'm there more often than at the house.
Yeah.
So then we've got a 40-year period of ownership of the cottage, and the denominator is 40, and the 15 is the number of years that it qualified for principal residence exemption. So 15 over 40 is exempt, and 25 is over 40 is taxable. And so there's still a significant tax amount to be paid that has to be brought into the planning by the advisors.
Exactly. So that speaks, of course, to the importance of documentation. How do you find that with people? Are they very clear?
Well, in order to make best use of the opportunity to make either the cottage or the house principal residence, you need to keep track of the capital improvements on both, because we don't know which ones are going to be just exempt and it doesn't really matter, and which ones are in fact going to become taxable, and then putting in that dock or putting in that new kitchen are absolutely of value. So my recommendations to everybody with multiple residential properties is always keep track of every nickel that you spend on either of them. We don't know now what's going to be used 20 years from now when decisions are made as to where will the principal residence exemption, but you certainly want to be able to help your experts do the analysis by saying, yes, the cottage is worth, the house is worth more than the cottage, but I put a ton more improvements into it. Therefore, the capital gain is smaller on the house. So it should be the one that is not used for principal residence.
Yeah, pay the tax on it. All right, let's walk through a scenario. You've got a cottage, you know there's a capital gain, and you had a slide here that you wanted to share with us.
So what I want to do is to sort of cast light on the normal way, I should say the most common way for cottages to transition from one generation to the other. It's purchased by the parents at some point and typically in joint ownership. And when the first parent passes, then the ownership will go by right of survivorship to the surviving parent, and then they'll go another 5 or 6 years, and then sadly they will pass, and then their will says everything goes to my kids. So probably 2/3 of our clients, that's their cottage succession plan. I don't really think it's a plan. To me, it's more like lighting the fuse on a time bomb, because that is absolutely the most tax inefficient, even though it's the most common way for that to happen. And so the slide that's there is illustrating the typical way that it goes at the death of the surviving spouse. I'm not going to go into details here, but I've assumed a cottage that was purchased for a couple of $100,000, $100,000 worth of gain, just cost base is 300, fair market value is 800, so we've got a capital gain of 500,000. If that all goes through the single tax return of the last spouse to die, then $133,000 in total tax is going to happen to the estate. Now, that is not just the capital gains taxes. That will include clawback of old age security. There's a number of other things, but this is a realistic number. If the client is permitted, encouraged, or not, given the alternatives of more tax efficient ways to do it. And so that would lead me to scenario 2, which is the next slide. So the parents are now saying, well, we're getting pretty elderly. The cottage is a lot for us to carry on, maybe financially, certainly physically. We're prepared to consider passing it on to the kids. The kids are enthusiastic. We've done our due diligence. They've got a cottage sharing agreement. We're ready to pass it on to them during our lifetime. So same cottage, but it's done the year before the parents die. Therefore, it's split onto 2 tax returns, mom and dad's tax returns. It's only partial clawbacks of old age security, and we have far more of the gain at lower marginal rates. And so simply by doing it the year before they pass is $106,000 of tax, and that's a saving of $27,000 over just doing the normal and waiting.
Yeah.
And then the most effective one, if we can again go to the next slide.
Yeah.
So when they come to you and say, this is what we're going to do, and here's our plan, and you say, that's a good plan, what I say to them is, however, if we transition, say, 50% of the cottage to them in the fall of 2026, and then in January of 27, we transition the second half to them, now it's going to be split onto 4 tax returns. And so we have not only lots more lower marginal tax rates, we also get a deferral. The first round of tax that has to be paid is a smaller chunk that's going to be paid in April of 27. And then we've deferred the second one until April of 28, and the advisors can say, fine, we'll keep that money, we'll invest that for you and further soften the blow. So just, this is not a sophisticated concept, but it's one that isn't frequently used. Our group will know this, but how many of us are proactive to say to them, if that's your intention, please talk to us now. We can come up with a plan that instead of you paying $133,000 out of family resources, it's only $88,000. And then they will wring your hand with thanks and say, aren't you a wonderful person? Can we do more business with you?
Well, and that's exactly what we want, mister. What about putting a family member on the deed? You know,
so one of the frequent things that happens is parents will say, oh, let's put a neighbor has said to us, why don't you put your kids, it's mom and dad, you've got 2 kids, why don't you put them on the deed as joint tenants? What could possibly go wrong with that? That will save you taxes. And they're not entirely wrong, because that could avoid probate tax when the second parent dies. But what they're not told is immediately that triggers a taxable disposition of 50% of the value of the cottage. And so you've just volunteered to spend tens of thousands, hundreds of thousands of dollars to Canada Revenue Agency, next April. And if you fail to do that because your advisor didn't mention it to you, the Canada Revenue finds out and they say, okay, well, that was a taxable disposition, you owe us the tax. You owe us the interest on the tax for the last 4 years till we found out. And because you're clearly tax evaders, we're now going to charge you multiples of that for penalties. Now, that's part of it. It's not tax efficient, regardless of what the neighbor says. The part the lawyer's going to say is, wait a minute, you've just told me that your daughter's on her 3rd marriage and you're not sure about that. If she's a 1/4 owner of your cottage, I guarantee that most recent son-in-law's divorce lawyer is going to say, oh, you've got 1/4 interest in a matrimonial home. We want half of your, we want half of your quarter, and we'd like that right now, please.
Of the
And so
cottage.
she turns to her brother and says, geez, can you buy me out? And he says, no, and the cottage gets sold. If a kid gets liabilities, if they run into financial trouble, if there's an execution, it's going to be on the cottage. So absolutely, advisors that don't want to be sued for negligence will caution against just adding a name to a deed. That's a very dangerous approach.
Can you talk to us then about using a trust?
Absolutely. So there's various different types of trusts. They are, again, not very well understood. In my practice involving the cottage succession, there's two types of trusts that I think are just wonderful. One is a joint partner trust or an alter ego trust, which are special, I think created about 99 by changes to the Income Tax Act. As we all know, generally speaking, if you settle assets onto a trust, you're going to be triggering the capital gains taxes. But there's special rules if it's if you're a Canadian resident client and you are over age 65, then you can put your house, your cottage, your non-registered investments into this joint partner trust, and it's tax neutral. You pay no tax whatsoever. This is a technique that keeps control of all of the assets for as long as the parents live. They're the ones that benefit from it for their lifetime. It completely avoids probate tax and probate delays and legal costs when they die, because only wills are subject to probate, not trusts. And so that's an advantage. And there's also other protective advantages for the joint partner trust too.
So how much does it cost, though, to set up a trust? And does it have to be recognized within, I thought, 21 years, or is that a fallacy?
It is for joint partner trusts. You're absolutely right, Patty. Most trusts have the 21-year deemed disposition challenge, but not a joint partner trust. They are special beasts. So I could be 65 and I could put my assets in and I could live to be 105, and no 21-year rule is going to affect me because it's tax neutral. It's not deferring things. It defers capital gains tax till I'm dead, which is no different than whether I had a trust. There's no administrative costs for the joint partner trust because the parents themselves, the clients themselves are the trustees. They're the administrators. There is a requirement to file an extra tax return every year, but the trust doesn't pay tax. It flows through to the T1, so they pay no more or less tax. It's tax neutral. It's a really good way to magically make a lot of problems for families go away.
Is it popular?
It's increasingly popular, particularly since 2015, when some of the tax rules with regard to testamentary trust changed. And so in 2015, a lot more people started to move to that. And then in 2020, when the cottage value started to go up so much and the probate taxes went up accordingly, then yes, more and more popular for the more sophisticated, higher net worth clients. Absolutely. So that's one thing.
Yeah. Okay. You've mentioned before, and I'd like you to elaborate if you could, a sprinkling trust.
Okay. So there are lots of different types of trusts. There's disability related trusts. There's Henson trusts. There's income, but one that is just tailor-made for cottage owners or second residential owners is called a sprinkling trust. And I won't get into the details. Anybody that wants more can get more on that, but it is an ownership vehicle for the children that allows them two huge advantages. So when parents pass the cottage on to the children, and it could be provided to them in the will of the last parent to die, if they're old school, that when I die, if I still own the cottage, it goes to the kids, but it goes to them as trustees of a sprinkling trust. Or it could be done next year if they want to deal with it now before the values of the cottages go up too much. Then they would create the sprinkling cottage trust and use that as the ownership vehicle. But huge benefits for your clients. Number one benefit, this is a very powerful asset protection trust. For 21 years after the children inherit the cottage, if one of the children gets divorced, that will be very sad for them. But it will not impact upon the cottage because the cottage is defined by the Ontario Court of Appeal not to be a matrimonial home and therefore exempt from claims on separation or divorce. It is also, because it's a sprinkling trust, it is, if a kid had creditors, it won't attach to the cottage. If they go bankrupt, the trustee in bankruptcy can't get involved because the kid is not the owner for the controller, yes, as trustee, but not at this stage the owner, and therefore it's completely exempt from third-party claims. So if you, advisors, if you know that there are children of your clients that might be having marital difficulties or have risky businesses, then a sprinkling trust is absolutely a wonderful way in which to say, we worked long and hard to build up our assets here. We are going to be spinning in the grave if 18 months after we passed our wealth on to the kids, the son goes bankrupt and the daughter gets divorced, and we see 3/4 of all our inheritance go down the toilet. But I only gave you half the advantages of the sprinkling trust. So the asset protection is one. The other one is generation skipping potential for capital gains taxes. So when the parents pass the cottage on to the kids, yes, there will be tax at that point. 20 years later, that cottage is quadrupled in value. But now maybe the children are ready to pass the cottage on to their children. But there's a huge potential tax hurdle there because of the gain. But if the parents were clever enough to provide their children with ownership in a sprinkling cottage trust, then the children have the option to bring the cottage out of the trust to their own children on a tax-deferred basis. It's not a taxable disposition. It is a tax-deferred distribution. And so it goes to a 45-year-old. Let's say the grandparents, when they died, their grandkids were 20 years old, and 20 years later, they're 40 years old, and they get the cottage. So tax was paid when the grandparents passed, no tax paid for the children's generation at all, and the next round of tax is going to be when the kids turn 84.6 and they finally pass away, and then there will be finally tax. So advisors, what can you do with a 40-year deferral?
Wow, we can do a lot, mister. Even I know that. Okay, so as an advisor who's watching, can you just give me the top 3 things that they should be doing with their clients when it comes to the cottage and transitioning, like 3 bullet points around the tax efficiency here?
Sure. Well, all of the advisors are going to be knowledgeable and diligent. They're going to find out what the assets are, what are registered investments, what are non-registered investments, what are liabilities, and, what are the assets. And so the house is an asset and the cottage is an asset. As soon as you hear the bell ring that says cottage, then it's opening the door for lots of very interesting planning discussions and lots of opportunities to garner a halo around your head that isn't just sell the cottage, it's complicated. I would encourage them then to say, have a conversation with the children. If you like the idea of keeping the family cottage in the family, in your family, and not somebody else's family, then it takes some planning to do that. And, let's get started. It's not necessarily expensive to start the planning. So that's number one. Start the conversation going. Reassure them that some of these horror stories that they've heard about divorces and in-laws and capital gains.
Wait a minute. Okay, carry on.
Managed by relying upon the expert advice of the financial advisors, of the accountants, and of the lawyers. And all of a sudden, grandma's great goal that those grandchildren are going to be sharing ownership of the cottage long after she's passed become not a problem that she's worried about, but here's the advisor that's helped her solve those problems and have this nice rosy future. So number one, have a conversation with the kids. Number two, if they get serious, encourage them to get these cottage sharing agreements. And then perhaps the most important is make sure that when these inheritances go down to the kids, they don't just have it in the normal will that says everything goes equally among the kids. They go equally among the kids in these inheritance trusts, which, by the way, apply beautifully, not just to the $800,000 cottage, but the $2.4 million worth of house and investments. Those should be protected just as much as the cottage.
Oh, yeah. Brilliant. Absolutely. So my last component here, as we sort of wind down the clock, because you've been talking about it, cottage protection and structure.
Yeah.
Is there protection that we've heard about in the past that simply doesn't work. Gifting a cottage, for example, I'm going to gift it and, or pay me $1 for it or something like that. And structures that you've seen definitely work better than others.
So one that can work very poorly is the old school. I just leave it directly to the kids. In Canada, 38% of marriages end in separation or divorce. If you've got 3 kids, do the math. Chances are there's going to be a separation or divorce. If there's a cottage ownership component, then you can wave goodbye to the cottage. So we can avoid that through a sprinkling cottage trust, for example. Another issue. I'm sorry, I've lost track. What was the other?
I was talking about the protection and the structure, where you see it work better or not at all.
Lots of times in the past, the advisors said, set up a corporate vehicle as a structure. And so what we're doing now is spending a lot more time untangling those, because at some point, the accountants that are listening will know, but I've forgotten. But several years ago, CRA said, you know what, sure, you can have a corporate structure for a recreational property, but we're going to treat the usage of that as a taxable benefit. And so the kids that now spend a couple of weeks at the cottage are going to find that they are now going to have to report, well, the cottages are now $2,000 a week to rent. And so if you use it for 2 weeks, we're attributing $4,000 worth of income to you as a taxable benefit. So corporations are much less used than they used to be. They do have a limited liability aspect to them, which can be advantageous, frankly, not as protective as a sprinkling cottage trust. So the various ownership structures could be direct ownership, which carries a lot of risk with it. You can modify some of those risks with the cottage sharing agreement, some of the internal risks, but not the external. Corporations, speak to your accountant, but they can be quite tax inefficient and quite annoying to have to pay taxes just to use your own cottage that you put a lot more money into than the $4,000 just to repair the roof. You can have the sprinkling cottage trust, which is my favorite. It's not perfect. It's not for everybody. For most people, it's going to be the optimum one. And then the final one is there are nonprofit corporations, in effect, trying to set it up like a golf course or something like that. But they're quite cumbersome. And ultimately, if the cottage is sold, it can, well, in any case, it's not generally recommended by the professionals once the due diligence is done.
Wow. It is 3:46. We've been going 45 minutes. I bet you could keep going. I love this topic. Andrew, I'm going to turn it back to you. Do we have questions coming into the queue?
Yeah, definitely. Lauren is accumulating some questions here. And, I'm sure it won't be any mystery to people that we're thinking about Cottage Webinar 2.0 right now, or perhaps one for your clients in order to investigate some additional topics here. But Peter brought up a really good point in terms of the integration of maybe where our banking solution, a custom solution, if you may, can be used. And one of the things is there is an opportunity or a lull in property markets to lock in some of these lower appraised values. But the next question is, where's the cash going to come from? And the reverse mortgage in a modern sense, the CHIP in a modern sense, financial planning, is really a cash flow management tool that does not have the pain point of an interest payment. So it can accomplish some of the goals that Peter's introduced there. So I'm going to ask Lauren to just administer some of the questions.
All right. Yeah, we have tons of questions flowing through the Q&A in the chat box. Andrew, this first question is I'm actually going to direct to you because we had a lot around like tax liabilities, the need for liquidity when gains are triggered. Do you mind speaking or addressing that?
Yeah, sure. Well, the proceeds from a loan, whether it be the CHIP reverse mortgage or any loan, does not have taxable consequences. So, obviously, as a choice to execute some of these strategies that Peter introduced, is you have a choice of digging into registered assets or non-registered assets to do that. That might not be effective. So, really at the end of the day, the choice of the loan in order to do that is giving really a cottager or a property owner permission, to investigate, how they can do it without disturbing the plans that they have. That's number one. The other thing in terms of our specialty in the reverse mortgage is our loans are not income qualified. So therefore, it's better suited to that better generation client based on their age as an actuarially qualified loan. So, having a credit solution is great. But, if you can't get it because you don't have enough income or a job, it becomes a bit of a challenge. But increasingly, I think the net tax effect has to be taken into account. I should mention also there's a little bit of a poll there. This is with respect to our next webinar topics. Certainly, if you want to just pop a response to A, B, and C in the chat, it will help guide us in terms of other good presentation topics. Lauren, next question.
All right, this one I'm going to direct to you again, Andrew. Someone's asking, how can I introduce a reverse mortgage to clients who are skeptical? What safety guards / features should I be emphasizing?
Yeah, absolutely. It is, many people might be joining and becoming familiar with reverse mortgage for the first time on the call. So should I acknowledge that, reverse mortgages, at least the way they're presenting, is quite a bit different than what you may have perceived. And, one of the best guidances to realize, of course, that is have a professional at your side. Many in the investment trade have insurance specialists, for example, that assist in the conversation. Our bank is well set up with the professionals nationally, almost 60 of them, to sort of guide you through the conversation, to introduce it for a fair hearing with clients. But as Peter had talked about, what I'm finding is just becoming an expert at sharing real life example stories of what other families have done. I personally focus on the Toronto affluent real estate marketplace and cottage country myself. I have a number of different stories where people have used these are affluent families that have used reverse mortgages effectively in order to better on a net tax basis. I can share the basics with them, and soon as the clients hear that they're missing out on something, they want to know.
Okay.
Warren?
I'm going to wrap up the questions here, and just for everybody who's on the line, I know there's a lot that were unanswered, but don't worry about it. Your HomeEquity Bank BDM or BDA will be in contact with you to help you or to answer those questions for you. But I'm going to hand it back over to Andrew really quick.
Yeah, this is great, and obviously, I believe the message is coming loud and clear that we've hit the nail on the head in terms of a great topic, and we're looking to extend that. But perhaps maybe you're looking for a point of engagement in order to continue your own personal dialogue. And Peter's been so helpful in preparing this guidebook that delves into some of these issues here. And we do have a copy of this booklet that he has prepared. There is a link here. If you hit that, it will essentially put you in the queue to interact with your HomeEquity Bank business development specialist in order to get a copy of this complimentary. But most certainly these additional questions that are being accumulated, you want to know the answers to those too. And very fortunately that I work amongst a very strong team nationally here at HomeEquity Bank that chances are we've seen similar circumstances. So I do encourage you to request a booklet and put us in the dialogue box to have this conversation.
Okay.
All right. So just Pattie, Peter, Andrew, thank you very much for hosting this very informative session. And thank you to everybody who's online for taking the time to join us today. Once again, if your question was not answered, don't worry. Your HomeEquity Bank BDM or BDA will be in touch with you. Have a good day, everyone.